Well, good afternoon. We're going to start the afternoon panel. Well, let me briefly introduce Professor Jane Stapleton. She is a member of the American Law Institute, and she's a professor at the University of Texas at Austin. She's also a research professor of law at the Australian National University, and she was a statutory visiting professor at law at Oxford University. She's very well known, and I don't need to say that, but a world's leading scholar on products liability and tort law, and she has made an extensively influence in those topics. And I think the particularity of Professor James Stapleton is his comparative background because of his experience in the US and his work in the UK and Australia. And and today she's going to she's going to talk about uncertain and unnecessary causes, asbestos in UK courts. So, Professor.
Thank you very much indeed. I'm very delighted to be here. Thank you very much for the invitation. Asbestos litigation is the longest and most expensive mass tort in the history of the three jurisdictions in which I principally operate: the United Kingdom, the United States, and Australasia. In the US alone, there have been more than 8,000 defendants and more than 700,000 claimants. One of the core problems in this asbestos disaster area is that plaintiffs are typically presented with great difficulties under orthodox rules in proving a causal link between a particular wrongful exposure and an asbestos disease. In my paper, I focus on an argument that's been increasingly bandied about in tort cases in general in the United Kingdom. This is the so-called doubling of the risk approach. And in particular, I analyse how the UK Supreme Court recently came to deal with this argument when defendants tried to use it to escape liability for the asbestos cancer called mesothelioma. The doubling of the risk argument is also, by the way, infecting another case before the UK Supreme Court, which deals with a mass action by military victims, veterans, of the nuclear tests in the 1950s. To understand UK law on mesothelioma, we must start with two foreign cases, our well-known hunting cases of Summers and Tice in the US and Cook and Lewis in Canada. I won't repeat the facts. Application of the orthodox proof requirement would have meant that the plaintiffs in the hunting cases would have lost their case because they couldn't prove on the balance of probabilities that it was more likely to have been one hunter rather than the other who had fired the shot which hit the victim. But the courts held that in such circumstances where, crucially, each of the possible sources of shot had been tortious, that the evidential difficulty arising from the impossibility of identifying the gun which fired the crucial pellet should redound not upon the negligent hunters, it should redound on the negligent hunters and not on the blameless plaintiff. Each shooter was to be held jointly and severally liable for the victim's injury. Now, the correctness of the decisions in these hunting cases has never been doubted in the United Kingdom. This normative approval of a radical departure from orthodox methods of proof of factual causation was justified on the basis that although it had the unattractive consequence that one of the hunters will be held liable for an injury that we all know he didn't in fact inflict, this is outweighed by the even less attractive alternative that the innocent victim should receive no recompense even though one of the negligent hunters injured him. And that's a quote from the Supreme Court. The basis on which these courts in the hunting cases were prepared in the interests of justice to abandon orthodox proof of factual causation became crucial in 2002 in the case of Fairchild in the UK's House of Lords. This presented the House with the classic asbestos problem where men who had contracted mesothelioma had been wrongfully exposed to asbestos by a series of careless defendants, some of whom were their employers, some of whom were occupiers of premises in which the men had been required to work. Now, mesothelioma cancer is not a cumulative disease in which each inhalation of asbestos generates a certain amount of disability. While it's true that the more a person is exposed to asbestos, the more likely it is that meso will be contracted, once contracted, the severity of the disablement is independent of the amount of asbestos to which the victim has been exposed, or at least that's how the courts in the UK have treated the expert witness evidence. In other words, mesothelioma is an indivisible condition. At present, we don't know the basic mechanism by which meso is triggered. The mechanism might involve just one fibre of asbestos, or it may require a threshold load of fibres. It may require an external stimulus, or it might not. It might involve only deeply embedded old fibres, or the asbestos involved might need to have been recently inhaled. We just don't know. The crucial point to note about the litigation in Fairchild was that the House of Lords made a very large assumption. It assumed that for all the plaintiffs in that case, every one of the sources of asbestos to which they'd been exposed were tortious sources. So, although Fairchild was unlike the hunting cases in that not all of those who'd exposed the victims to the risk of injury were before the court, as they had been in the hunting cases, in Fairchild it was assumed, just like in the hunting cases, that all those who had exposed the victims to the risk of the injury were tortfeasors. Now, given that very large assumption, it was a relatively simple matter to extend the unorthodox approach in the hunting cases to the mesothelioma claims and allow the plaintiffs to establish a causal connection between one defendant's exposure of the victim and the mesothelioma merely by establishing that the defendant had materially increased the risk of mesothelioma. But what if one of the periods of exposure was due not to any tortfeasor, but to the carelessness of the victim himself? This was the issue raised in the next mesothelioma case to reach the House of Lords in 2006, Barker and Corris. Because here the plaintiff had been self-employed for a period and had carelessly exposed himself to asbestos. This meant that in Barker, and unlike in the hunting cases in Fairchild, it was possible that the injury had not been due to a tort at all. The House of Lords held that the special doctrine applied even on these facts. The Lords also held that, rather than being joint and several, liability under the doctrine should reflect the relative contribution to the total risk made by the individual defendant. But this aliquot liability part of the decision in Barker was swiftly overturned by Section 3 of the Compensation Act 2006. So, in combination with this legislative move, the decision in Barker is explosive. The reason is that Barker detached the Fairchild doctrine from its most powerful normative rationale, the rationale it had shared with the hunting cases, namely that even if we don't know how the injury had been caused, we're sure it had been due to a tort committed against the victim. After Barker, this wasn't the case. The situation for mesothelioma defendants in the UK was now this. If in breach of duty, a defendant had exposed a plaintiff to a material risk of mesothelioma, he would be held jointly and severally liable to the plaintiff. It didn't seem to matter that other sources of asbestos were not due to tortious conduct. This meant that deep pocket defendants had become massively exposed to asbestos liabilities. This was particularly so with emanations of the state, such as schools within the state school system, hospitals in the National Health Service, and local authorities in general. The state doesn't die or go out of business, so these massive liabilities were set to strike home to the taxpayer. The stage was now set for the 2011 Sienkiewicz litigation, in which the UK Supreme Court was called upon to clarify further the Fairchild doctrine. Lord Phillips stated that doctrine as, and I've set this out on a handout, quote, "When a victim contracts mesothelioma, each person who has, in breach of duty, been responsible for exposing the victim to a significant quantity of asbestos dust and thus creating a material increase in risk of the victim contracting the disease will be held jointly and severally liable for causing the disease." Now, Sienkiewicz concerned claims by the administrators of the estates of 2 women who had died from mesothelioma. Each administrator sued only one defendant. In one case, the defendant had employed the deceased woman, Mrs. Costello, for 18 years. In the other case, the defendant counsel had been responsible for the state school attended by the victim, Mrs. Wilmore, who died aged only 49. It was agreed by both sides that even if the relevant defendants had, in breach of duty, exposed the victim to legally significant quantities of asbestos, the victim had been exposed to a much, much greater volume of asbestos from other sources. Now, 2 features distinguished these claims from those in Fairchild. First, in these claims, the claimants could only identify one blameworthy source of risk, that due to the sole defendant's breach of duty. The defendants seized upon this to characterise the claims as single exposure cases. Secondly, estimates had been, or could in theory have been made, as to the total risk confronting the victim of this single identifiably blameworthy source of risk, and of the total risk posed by the other sources of risk alone. Given these features, the defendants argued that the rationale for the Fairchild doctrine is absent in single exposure cases, because they claimed a conventional approach to causation is possible by applying the doubling of the risk test. That is, by comparing the 2 risk estimates and asking whether, on the balance of probabilities, the defendant's breach had resulted in the victim facing at least a doubling of the total risk from other sources. Now, if the defendant's argument that the doubling of the risk approach applied in all single exposure claims were to be accepted, they would prevail in the instant cases. They'd win the cases on these facts, because in these cases, the breach had not resulted in a doubling of the total risks arising from other sources. For example, as I set out in the handout, the evidence accepted by the trial judge in the claim involving Mrs. Costello had been that the total risk of contracting mesothelioma to which other sources had subjected the relevant public in general was 24 cases per million, and that the defendant's wrongful exposure of Mrs. Costello had only increased this risk up to 28.39 cases per million. Now, remarkably, the defendants had conceded that in cases of multiple blameworthy exposures, causation could not be established in this, what they called conventional doubling of the risk way. And so Fairchild applied, they said, to those cases. But this concession presented the defendants with a major difficulty, because it was highly probable that some of the environmental asbestos pollution in these cases, in Mrs. Costello's case, for example, had been due to some tortious, albeit unidentifiable, cause. So, although almost certainly it was the case that these were actually multiple blameworthy exposure cases. Now, the defendants sought to avoid that difficulty with an extraordinary argument. They argued that the breathing of polluted ambient air should merely, and I'm quoting them now, should merely be regarded as part of the ordinary vicissitudes of life, at least where this pollution was not caused by an identifiable individual. In other words, we're meant to forget about all those sources. In effect, this was an assertion that Fairchild doctrine only applies where there were multiple identifiable blameworthy exposures. Yet in Fairchild itself, there was no indication that the doctrine was to be limited in such a way, and it's unclear what normative basis such a limit could have had anyway. So, since there's no normative distinction between the single exposure cases in this case and those in Fairchild, the defendant's argument about the availability of proof on the basis of the doubling of the risk approach should be equally applicable to the claims in Fairchild itself. an estimate of the total risk faced by Mr. Fairchild due to the breach of a particular defendant could, in theory, have been compared to an estimate of the total risk arising from other sources of risk alone. If then, as the defendants in Sienkiewicz say, proof on the basis of the doubling of the risk is legitimately available when such estimates are possible, the evidentiary gap in Fairchild would be revealed to be not an insuperable rock of uncertainty, as the law lords had claimed in Fairchild, but the mere happenstance that these risk estimates had not been gathered in those cases in Fairchild. In other words, the rationale for the entire Fairchild doctrine, on which recovery from mesothelioma precedes the United Kingdom, would vanish. Let me now turn to statistics and ask, when is the doubling of the risk approach statistically valid? Now, in the determination of whether a defendant's breach contributed to the victim's disease, the use of risk estimates, based, for example, on epidemiological data, raises three questions. First, as a matter of statistical analysis, when is it valid to compare such risks? This is what I call the statistical validity issue. Secondly, are the data underlying these estimates reliable and a close enough fit to the facts of the case in issue? I'll call this the probity issue. And thirdly, and we've talked a lot about this, even when statistical comparisons are valid and the data is both reliable and relevant, when, if ever, should the law accept such evidence, based as it is on group data, as the sole grounds for the legal determination of what actually happened in an individual's case? And this is a purely judicial policy issue. Now, it deserves emphasis that only the first of these matters needed to be addressed by the Supreme Court in Sienkiewicz, because, as I'll explain, the principles of elementary statistics expose the defendant's argument to be statistically invalid. On the second page of the handout, I set out where comparisons of risk estimates are statistically valid. Let me go through them. Take scenario one. The comparison of risk estimates is valid as a matter of statistics, where we know that these estimates represent mutually exclusive ways the injury may have been caused. And we seek to estimate the likelihood it was one way which had operated in a particular case rather than one of the other possible ways. So it follows that such comparisons are statistically valid where the estimates relate to mechanisms which, even if the details are not understood, are known to involve different agents, such as where a collision might have been with a blue taxi or with a red taxi. A birth defect might have been due to a pharmaceutical or a background risk. A lung cancer in an asbestos-exposed smoker might have resulted from either a mechanism involving tobacco but not asbestos, or a mechanism involving asbestos but not tobacco, or a mechanism involving both tobacco and asbestos, or a mechanism involving neither tobacco nor asbestos, but some other background carcinogens such as radon. In such cases, the comparison of separate risk estimates for each mechanism does provide a measure of the likelihood that one mechanism was operative rather than the others. For example, that it was a blue taxi, not a red one, involved in a collision, though of course it provides no indication at all of the likelihood it was one particular blue taxi that was involved. Even where a disease is taken to result only from a single agent, the so-called single-agent diseases, such comparisons could be statistically valid in at least two contexts. One is where the figures carry information about variable susceptibility to the agent. This is scenario 2 on the handout. A good illustration is the hypothetical given by Lord Mackay in the 1987 case of Hodson. concerning contraction of dermatitis from brick dust. Say it was established that of 100 people working under the same conditions as the pursuer and without facilities for washing at the end of the shift, 70 contract dermatitis. But of 100 people working in the same conditions as the pursuer, when washing facilities were provided, at the end of the shift, only 30 would contract dermatitis. Now, within the 70 victims in the former scenario, there are two mutually exclusive classes. A cohort of 30 whose susceptibility would have been overcome even with washing facilities, and a cohort of 40 whose higher biological resistance had only been overcome by the extended exposure to the dust. Where an individual victim didn't have washing facilities and contracts dermatitis, it's, as a matter of statistics, valid to conclude that the victim was probably a member of the latter, higher biological resistance cohort, and that therefore the lack of washing facilities contributed to his dermatitis. In other words, the data supports the conclusion as to which of two mutually exclusive scenarios probably operated, namely that the victim's dermatitis probably followed an etiology involved when a robust individual succumbs after extended exposure, rather than the etiology involved when a susceptible individual succumbs after a shorter exposure. Similarly, comparison of risk estimates in relation to a single agent disease would be statistically valid if it were accepted that the mechanism involved just one unit of the agent. This is scenario 3 on the handout. And basically what I'm doing now is tracking through all the examples given in Lord Phillips' judgment in Sienkiewicz, although he reacts differently to most of them. This is scenario 3. For example, where it was accepted that a disease resulted from one mosquito bite or a single injection, as was the case with some of the claims in the Creutzfeldt-Jakob disease litigation in the UK in 2000. So if the medical consensus were that mesothelioma were a single-agent disease and caused by a single fibre of asbestos, the law could legitimately assume that the victim's disease had either been caused by a fibre from the defendant's breach or a fibre from one of the other sources. In such circumstances, it would be statistically valid to compare risk estimates of the two scenarios that were at stake in Sienkiewicz, the total risk faced by the victim and the total risk from other sources, apart from the defendant's breach, and use that comparison to judge the likelihood that it was a fibre from the defendant's breach that operated in a particular case. For example, a comparison of the 28.39 cases per million risk faced by Mrs. Costello with the 24 cases per million risk faced by the general public could validly be used to deduce, on the balance of probabilities, the degree of likelihood that it was a fibre from the defendant's breach that had operated. And since 28.39 is not more than double 24, the conclusion would be that this was unlikely. But there is no consensus as to how mesothelioma is caused. Though there is the possibility that it may be caused by an agent other than asbestos, courts treat it in effect as a single-agent disease, and this is acceptable if one assumes, as UK courts do, that mesothelioma is almost always caused by the inhalation of asbestos fibres. Because then it would follow that for any individual case, more likely than not the mesothelioma was asbestos-related. It's in the subsequent issue, namely which sources of asbestos were likely involved in the individual case, that the rock of uncertainty is located. So it's not known how asbestos causes mesothelioma, let alone that this process involves a single fibre. It's feasible that the mechanism by which asbestos caused mesothelioma in Mrs. Costello involved fibres from both the defendant's breach and from other sources. This means that it's not known that the two risk estimates, accepted as evidence in relation to Mrs. Costello, represent mutually exclusive ways her injury might have occurred. And so the comparison of risk estimates, which is intrinsic to the defendant's doubling of the risk approach, is simply statistically invalid. By the way, this point is equally applicable to the recent atomic veterans litigation in the UK, because where the one particular exposure to radiation in breach of duty materially increased the risk of a disease, yet there was in that case background radiation that also materially increased the risk of that disease. So it's statistically meaningless, at least so long as ignorance of the disease mechanism means it's possible the mechanism by which an individual's disease came about involved contributions from both sources of radiation to require the claimant to show that the risk from the tests, the breach, was at least twice that from other sources. Yet remarkably, that is how the atomic veterans litigation has been proceeding in UK courts. Okay, returning to mesothelioma. Because the comparison of risk estimates is, in the case of a single agent disease of unknown mechanism, simply invalid as a matter of statistics, a victim of such a disease is unable to establish that a small source of risk, that is small relative to the total risk, was involved in his contraction of the disease, and a defendant responsible for one of those sources cannot show that it was uninvolved. It's on this basis, of course, that the restriction of the Fairchild Doctrine to diseases of unknown mechanism that are only caused by the same agent might be rationalised in such single-agent contexts, an attempt to use risk estimates to show that the disease was likely to have been caused by a relatively small source of risk rather than another source would simply be statistically invalid. So the barrier to proof in these cases is not simply high, but insuperable as a matter of formal statistics. This is important because the Fairchild Doctrine is predicated not merely on the difficulty of proof, but upon the absolute impossibility of proof. Now, comparing estimates of risk on the invalid assumption that the risks are independent recently led to the grave miscarriage of criminal justice in the famous Sally Clark case, which, for those of you who know the case, will remember ended in the wrongly convicted woman's suicide. So it was to be hoped that the fundamental flaw in the defendant's argument in Sienkiewicz would have been identified clearly and at an early stage of the litigation. And remember, this is the lead litigation for all mesothelioma claims in the United Kingdom, so this is the case on which they're all going to turn. But this didn't happen. It went right up to the Supreme Court, just as it isn't happening at the moment in the atomic veterans litigation. Now, fortunately, when it got to the Supreme Court, they unanimously rejected the defence argument that because of the alleged availability of proof by statistics, Fairchild didn't apply to single exposure cases. But no judgment was rested on the straightforward basis that the argument was simply statistically invalid. The court laboured without the sort of assistance of, quote, appropriately qualified statistical experts that the Royal Statistical Society had advocated to the Lord Chancellor courts should have in the wake of the Sally Clark tragedy. Indeed, only Lord Phillips squarely addressed the issue of statistical validity in detail at all. And he was particularly concerned to reject the sweeping and flawed statement about doubling the risk that had been made by the Court of Appeal in this case, which I also set out in the handout. Now, in my paper, I analyse in detail how he coped. In doing so, I explain scenario 4, another context in which data on relative risks may be validly compared, namely where we have a single agent disease and where there had been multiple sources of agent operating simultaneously, of which the specified source is dominant, well dominant. And I give an example of bladder cancer, which is one of the cases that the courts talk about in the UK. Say bladder cancer can only be caused by a particular agent, amines, and a victim had been for exactly the same period of time simultaneously exposed to only two sources of that agent, occupational amine exposure and amines contained within the cigarette smoke of his bags. If the volume of the agent from occupational exposure was really very much considerably more than double that from the smoking exposure, it would be possible to infer that it was probable that the dominant source of the agent, that is occupational exposure, contributed to the disease. And this is because whatever the mechanism of the cancer, it's probable that the occupational exposure was somehow involved. But it's not a corollary of this proposition that the minor source of risk probably didn't contribute. For example, if the mechanism involved a threshold, that source would have contributed to it. This represents scenario 5, in which it is not statistically valid to compare relative risks, namely where the mechanism by which the disease is contracted is known to require multiple units of an agent, and where there had been multiple sources of agent operating simultaneously, and the source we're interested in contributes only a small proportion of the total amount of the agent. If the mechanism is cumulative, as in asbestosis, the tortfeasor would only be liable in the UK, at least, in respect of the share of the disease for which he was responsible. Alternatively, if the disease is indivisible and is known to require multiple units of an agent forming a threshold, the tortfeasor would have contributed some amount to the threshold. Remember, they're coming in simultaneously, and therefore to the contraction of the disease. I then go on to discuss scenario 6, again tracking Lord Phillips' discussion, but correcting it along the way. Scenario 6 is where the mechanism by which the disease is contracted is known to require multiple units of an agent, and where there had been multiple sources of agent, but operating sequentially. Now, Lord Phillips saw no reason in principle why the doubling of the risk approach shouldn't be applicable in such a case. He said, where the innocent exposure came first, there may be an issue as to whether this was sufficient to trigger the disease and whether the subsequent tortious exposure contributed at all. Lord Phillips is wrong. You'd need much more known about the mechanism for the doubling of the risk approach to be validly used to exculpate the later exposure. For example, it might be that there is a threshold sufficient to trigger the disease, but which only becomes potent at a time that postdates both exposures. Such dormancy in the mechanism would permit the involvement of all sources of agent, including a small tortious contribution that followed a large innocent one. Again, the predicate for the validity of the doubling of the risk approach would be absent. Now, Lord Phillips' dictum seems based on the very common but misleading conflation of two distinct issues. One is whether the tortious contribution of an agent made a causal contribution to the occurrence of the injury that in fact occurred. The other issue is whether that injury represents damage relative to the position the law determines the victim had been entitled to be in. And in the paper, I give an example of this involving the sequential administrations of medicine to a road accident victim. This brings me to an extraordinary feature of mesothelioma litigation in the United Kingdom, and in fact elsewhere, which we should examine and which by omission the Sienkiewicz litigation demonstrates well. This is the failure of the defendants to raise an explosive argument that appears open to them. The Fairchild Doctrine only assists a claimant to overcome proof of factual causation. But claimants must still prove all the other elements of the claim. One such element is that the conduct of the individual defendant exposed the victim to a foreseeable and unacceptable asbestos-related risk in breach of duty, the breach issue. Another element is the one I just mentioned, that the victim's mesothelioma represents damage relative to where tort law holds he or she had been entitled to be. Now, this benchmark against which the notion of damage is measured is a normative one. It's a construct. Though understandably, until the era of toxic torts, in which the mechanism by which injury occurred might involve a threshold that could become oversubscribed, this point wasn't fully appreciated by courts. So let me explain. To succeed in Sienkiewicz, Mrs. Costello's administrator should have been required to prove not only that the breach of the defendant contributed to, that is, was a cause of, the contraction of her mesothelioma, but that this injury represented damage relative to where she had been entitled to be. Now, in most tort cases, plaintiffs have no difficulty proving that their injury also constituted damage in this sense. If a motorist negligently swerves and breaks your leg, you have no difficulty proving that the prospects you had been entitled to enjoy included an unbroken leg, and that therefore the tort had caused not just an injury, broken leg, but damage relative to where you were entitled to be. But sometimes an injury does not represent damage. It doesn't damage the prospects to which the law says you had been entitled. For example, in the famous New Hampshire case of Dillon, a boy sitting on a high girder on a bridge leaned over, lost his balance and instinctively threw out his arm, and to save himself from falling took hold of an uninsulated wire strung near the bridge by an electricity company. He was electrocuted. And it was rightly held that the tortious aspect of the company's conduct, namely failing to insulate the wire, was a cause of this injury. However, the law then also has to ask, what prospects had the boy been entitled to? Suppose the facts showed that the only tortious conduct to which he'd been subjected was the uninsulated wire, and that had he not been a victim of that conduct, that is, the wire had been insulated, he would have fallen to the canyon floor because the wire wasn't strong enough to bear his weight, and he would have died at the moment of impact. In these circumstances, the defendant would not have to pay the estate of the boy any compensation at all, since the tortious conduct to which the defendant had subjected him had, to quote the judge in Dillon, deprived him not of a life of normal expectancy, but of one too short to be given pecuniary allowance. His life or earning capacity had no value. Now, there's a strong normative argument that the prospects to which a plaintiff should be held to have been legally entitled are not merely those he would have enjoyed had he not been subject to this individual defendant's tortious contribution to his injury, but to those prospects he would have enjoyed had he not been subjected to any tortious contributions to that precise injury. What if, in the future, in such a case, a defendant were to concede that by virtue of the Fairchild Doctrine, the contribution of inhaled fibre due to his breach must be taken to have contributed to the woman's injury, to her mesothelioma? But the defendant then goes on to raise the issue of whether her mesothelioma represented damage relative to where she'd been entitled to be. The mechanism by which this classic toxic tort disease occurs might involve a step that could be oversubscribed. That is, it could have been that there were more than enough inhaled fibres to complete this step. If then the innocent fibres present would alone have been sufficient to complete it. If so, how have the tortious contributions to the injury damaged the victim relative to where he or she had been entitled to be? So let's look first at what would have happened in Fairchild itself if this argument had been raised. And remember, in Fairchild, no individual defendant had been responsible for more than a minority of the total fibres inhaled by the victim. Now remember, the Fairchild Doctrine relieves the claimant from proof of factual causation between the defendant's breach and the victim's mesothelioma. But it doesn't relieve, as it stands at the moment, it doesn't relieve the claimant from having to prove that the mesothelioma was damaged relative to where he'd been entitled to be. Now, if I'm right that courts, when eventually confronted with the normative benchmark issue of what is damage, if I'm right, that they'll determine this to be where the claimant would have been had he not been subject to any tortious contributions to his injury, the Fairchild claimants would still be able to succeed. That they'd be able to prove that their mesothelioma did represent damage because, remember, in Fairchild, it had been assumed that all the fibres inhaled had been tortious. Clearly, in the absence of all those fibres, those men would not have contracted their mesothelioma, so that injury does represent damage relative to where they were entitled to be. But it's now been held that the Fairchild doctrine can apply when not all sources of fibre were culpable. As Sienkiewicz shows, a UK mesothelioma claimant can use the doctrine to establish causation against a jointly and severally liable defendant, even where that defendant's contribution is a very small fraction of the total inhaled fibres, and where the vast bulk of inhaled fibres might have been wholly non-tortious. So the explosive question becomes, what if in the future a defendant in a Sienkiewicz type case puts the claimant to proof on the requirement that the victim's mesothelioma represents damage relative to where he or she is entitled to be? The answer must be that unless the doctrine is further extended so that it covers not only proof of factual causation, but also proof that the injury represents damage, a Sienkiewicz type claimant will be unable to establish her claim because she'll be unable to prove the Dillon point, that her injury represented damage. This is because since the mechanism of mesothelioma is unknown, there is the possibility that even in the absence of all the tortious fibres, there had been so many non-tortious fibres in Mrs. Costello's body from the general environment, she would have contracted her mesothelioma anyway. Now, for reasons I discuss in the paper, extension of the doctrine seems likely. So it's likely that the situation will continue to be that any UK defendant in a mesothelioma claim who, in breach of duty, had exposed the victim to a material quantity of asbestos will be jointly and severally liable, even though that quantity is extremely small relative to the total inhaled, and virtually all of which total may have been completely innocent. Now, the impact of this state of affairs will be felt most by government and through it by taxpayers. This is because it will commonly be the case that a mesothelioma victim in the UK will be able to point to a period of exposure for which an emanation of the state was responsible. This might be a state-run school, a National Health Service facility, or some local authority premises. So long as breach can be established, such a claim will succeed against the state. Unlike private defendants, the state doesn't go out of business, and so it will be the preferred defendant. In other words, in the future, many, if not most, UK victims of mesothelioma will be able simply to sue the state on the basis that, more likely than not, they experienced a non-de minimis exposure to asbestos either at their state school or in an NHS hospital at a time when it was known that there was no safe level of asbestos. Extraordinary though it seems, this seems that what we've got is this, that the common law courts, along with Parliament in the shape of Section 3 of the Compensation Act, have, in effect, but unwittingly, created for most mesothelioma victims a taxpayer-funded compensation system with tort-level damages. It's certainly true that even before the decision in Sienkiewicz, the UK government seemed very nervous indeed about its exposure to tort liability for mesothelioma. In 2008, it created the extraordinary Diffuse mesothelioma scheme, which entitles mesothelioma victims who've not received tort damages from any party and aren't eligible under any other state compensation scheme to an extremely modest one-off lump sum payment, so long as their exposure occurred in the UK. It remains to be seen how effective this move will prove in suppressing mesothelioma tort claims against what will be the obvious target defendant in the UK, namely the state. Thank you for listening.
Jane, your principle about the plaintiff proving damage, would you extend that to the situation where the defendant says, well, no, at the time you contracted mesothelioma, you hadn't, without our dose, had sufficient, but we're pretty sure within 2 years, 3 years, or whatever. So you not only have to prove damage, but you have to prove the extent of damage. That is, the extent of damage on the defendant's account here is that you only suffered an acceleration of your mesothelioma by 2 years due to the defendant's exposure. It seems logical to me that if you have to prove damage, you also have to prove the extent of damage where there is some damage. That is, suppose the Dylan child, you know, it was a long way down, a real long way down. And
no, you're right. If I had time, I'd tell you, this notion of damage, or where you're entitled to be, has a lot packed into it. The interesting phenomenon that I talk about in the longer paper is, say we know there's a mechanism. I mean, you could imagine a poison glass, and we all put in a non-sufficient dose, but naturally there's more than enough innocent doses, and you would have died anyway. So the one issue is contribution to actually what happened to you, and I'm saying that there's an issue there. But there's also an issue that even if it's true that the defendant, I did contribute to your mesothelioma happening at this stage, you have another issue of that would it have happened later, right? But also we have a case in the UK called Smith and Leach brain, which is a case where what happened, the defendant contributed to a cancer. But then they show that it's our classic case for ultra sensitivity, extra sensitivity of a, you know, I don't know what your classic case is, but our canonical case is Smith and Leach brain. And due to the defendant's fault, the person was burnt on the lip. That was a reasonably foreseeable consequence, but unexpectedly what this did was trigger an underlying proclivity to cancer. Question, the cancer was not reasonably foreseeable, it didn't matter because unforeseeable extent's okay because you're ultra sensitive, fine. But you get a discount for the possibility that at some point in your life, the underlying susceptibility will have been triggered. So, yeah, that's all damage, packed into this normative benchmark of what damage means. So, where you're entitled to be. You're not entitled to be better off than what fate had in store for you.
Right, but what I want to focus on is the procedural implications of the idea that the plaintiff must prove the extent of damages. Mm-hmm. Because if that's the case, Jane, in every wrongful death case, what the estate or administrator must prove is that no other cause of death would have intervened between the time of the decedent's death and what actuarial death would have occurred at. That's the logical implications. And to me, that's just a completely unwieldy...
We do it all the time in the UK.
...system. Well, and I would observe that we don't do it at all in the United States. Let me say this. I think if the defendant comes in prepared to prove that the plaintiff had an ultrasensitivity, and I'll let Richard talk about what the standard of proof is, but it seems to me that the only way this limited damage concept makes sense is to put the burden of proof on the defendant, because otherwise we've put the burden of proof on the plaintiff to eliminate all possibilities here that might exist, and that's proving a negative, which makes
but no. But I don't think we ever do that, do we? We never ask the plaintiff to prove a negative. We don't do that.
But that's the logical implication.
That's not what this happens every day in the UK. every day in the UK in these wrongful death cases, you get actuarial statistics out, and the plaintiff says, here's the book, this is what it's normally like. If the defendant wants to raise another issue, down to the plaintiff to knock it back.
Sorry, say that last part again, Jane.
So we have these standard tables.
Yeah.
So a person who's a smoker, who's 45 and is now dead, how long would he have worked for, what are his prospects, and you get a number. It might be that the defendant has some particular evidence about this particular person, that he's, I don't know, an extreme sports geek, and raises that issue. It'll come back to the plaintiff to then go and prove what they want to prove. But the burden doesn't shift. But my point is,
the burden of pleading is on the defendant.
The numbers going on damages in the UK are done not by juries. So you have problems that we don't have. It's not in our system, would not justify shifting the burden of proof to the defendant to overcome what is an American problem about juries and procedure. We don't have those problems, so we're not going to shift it.
But even in the British system without juries, what you're saying, Jane, is that the burden of pleading on this unusual aspect that might have foreshortened the actuarially predicted death is left with the defendant to raise.
But that's always the case if there's something out of the ordinary, that you proceed on the normal situation. And what will normally happen, though, is that it won't have been, in our system, you as a defendant should not ambush the person. It should be out there in the documents to go back and forward, so the plaintiff will have been alerted to the fact that the defendant has this stuff about your guy indulging in extreme sports. You'll have to go out and get something to back up your different numbers or the standard numbers you want.
Okay, we can disagree on where the burden of proof is, but I'm comforted by your acknowledgement that the burden of raising the issue, burden of pleading, as I would put it, is on the defendant in these situations, rather than with the plaintiff to eliminate all possibilities that might exist. I have one more question for you, and that is, when I read, and I don't know how to pronounce the name, this is like, how do you pronounce Daubert, right?
Sienkiewicz. Yeah, it's got a lot of syllables, and I do this because I have Polish friends, and so out of respect for my Polish friends, I learned how to say it.
Okay, I can't. I'll leave it to you to say it. But I was astonished when I read that case that there was agreement that the increase in risk from the defendant's exposure was from 24 to 28.6, which is a relative risk under 1.2. And where in the world, my question is, did they come up with that?
I know.
And why did the plaintiff agree to that?
I know. I think what's extraordinary about this case is it got even into trial court. I mean, that it's statistically invalid. These numbers, I mean, in one stage, and remember these people in the end win, but in the Supreme Court, Baroness Hale describes the finding of the trial judge on the statistics on the Wilmot case, finding these numbers from nowhere. She said that finding was heroic. I think she was absolutely
This is
right.
more than heroic. This is heroic squared.
Yeah, I agree. But my point is that it's a terrible condemnation of the law and science divide that no one on the teams, and I have to tell you that after the Court of Appeal came out, and I knew they were running this, and the QC running this for the lead defense QC was the person I had helped on Barker. So we're friends. And he said, I lost in Sienkiewicz in the Court of Appeal, but we're going up. And he said it to me. And I wrote back and said, you can't, this is a crazy argument. He said, no. He said, why is it a crazy argument? And I sort of explained why it was statistically invalid. He said, oh, no, I think we're going to run it. And then the other side rang me up and said, and then I published something in the LQR saying why Sienkiewicz in the Court of Appeal was wrong. So the plaintiffs rang me up and said, oh, well, tell us, can you explain us again why it's invalid? So I explained it. Then when they went and actually had the hearing, I think I said something yesterday, it was so incoherent from both sides that eventually, even in the judgment, Lord Phillips says, we asked counsel to explain the argument. And counsel said he didn't really understand it himself, and I'm tearing my hair out. So what do you have to do to get these people to understand the argument? So at least they got the right result. But as you say, that the evidence was terribly thin, the science was non-existent, and the maths was non-existent. So it's a wonderful case to bring before people interested in law, science, and statistics here. Good result, but bad reasoning.
Just as an aside, really, but I just want to take your side on this discussion. It's rather typical in the United States in specific causation situations where the plaintiff has the burden of proving that other possible causes weren't the cause of their particular disease. They, throughout that discussion, do have the burden of ultimate persuasion that the alleged cause was the cause. But very, very frequently, the courts will say, the burden of production, of setting forth other possible causes, is in fact on the defendant. The defendant has to come forward with other plausible causes rather than to put the plaintiff to the burden of disproving everything on earth. And that happens every day in American courts. There may not be a clear rule about what that is, but that is the normal way in which that issue is resolved. And it sounds to me exactly the same way this wrongful death situation is resolved.
It sounds like it works out the same way.
Yes.
Professor Wright.
I think that's correct, Joe, but I think that Mike was making a different point. Because what Jane is talking about is after causation's already been established by this defendant. So we've already kind of gone through all the sort of, elimination of other possible causes the sort of argument of by elimination, this is what caused it because all the others are gone. We've already gone through that. So I think you're thinking of a different situation. So what Mike's talking about and what Jane's talking about, if we've already proved causation, specific causation, but now the defendant wants to get off the hook because he's saying, even though you've proven negligence, you've proven causation, no problem, you're not going to be able to recover because luckily for you, something else that wasn't tortious would have caused this at some point or right now. And as you know, I think we all agree that as a general proposition, if that's true, that we should not let them recover for what would have occurred anyway without tortious causes. But I'm along with Mike in thinking that at least as a normative matter, it's better to have the defendant bear the burden of persuasion and not just production on raising that issue. And from the major cases in the U.S., you take Dylan, you take the overflown dam cases, you take the multiple fire cases, the courts explicitly say in those the burden of persuasion, the burden of proving this is on the defendant in the U.S. And it seems to me it's a better proposition. You've already gone through proving this person negligently caused your harm. Now you want to get off the hook by saying, well, it would have happened anyway due to something else. Maybe even if that something else didn't actually cause it, but it would have. It was preempted. Well, then I think it's only fair to say the burden should shift to the defendant to prove that. And I think the proof should be, and I know Michael and I have argued about this, the proof should be, and David Robertson has argued this in terms of pre-existing condition, the other sort of situation that Michael talked about, that it should be proof really beyond a preponderance of the evidence. It should be pretty clear proof that it would have happened anyway before you're going to have the plaintiff lose the recovery that they've proved all the basic elements for.
I think issues of where the burden should be is a matter specific to a jurisdiction, and I think it's just, it's a religious position, so I can't really answer. All I know is that the UK is not going to shift burdens to defendants anytime soon.
What about with the job? I forget which case it was. The case in
Jobling.
Yeah. And where was the burden on that one?
The burden is solidly on the plaintiff. In fact, I don't know whether anyone here can name any case in the UK where the burden has shifted on any issue to the defendant. The burden of persuasion. I can't name one. That's a defence. I'm talking about the elements. Yeah, sorry. Subject to the burden of persuasion is always on the defendant and defences, but in terms of the core elements of a claim, I don't know one issue, not even an exceptional doctrine in which burden of proof persuasion is shifted to the defendant. It's just not done.
The issue about consent and battery, but it's debated whether it's a defense or an element.
That's true,
yeah.
But that's because the character is debated, yeah.
Yeah.
And it would flow from which character it was, where the burden was. Go for it.
And that is, why do all your asbestos victims sue employers exclusively? That is, I can understand suing employers and suing the product manufacturers. You have products liability in the UK. Why are plaintiffs ignoring potential?
Easy, because we have compulsory employers insurance. So you know the money is there behind that defendant. Why spend more costs suing other people? And also, traditionally, it's also a cultural thing. Traditionally, I think when we had a Royal Commission into Personal Injuries in the 70s, so a long time ago, but he found that something like half tort claims were by employees against employers, and basically the other half were road accidents. Why? Because in both those claims you had compulsory insurance. Okay. So culturally, you have people who, if they're injured at work, immediately think union, insurance, claim against the employer. So and people don't need to think of other targets, because that's where all the machinery is available for you. And you'll probably first go and get your state benefit for disablement. So you're getting something, and then you build up a claim, and you'll have people who've been injured at work, and they'll have gone to their union. So the entire environment is pointing towards your compulsorily insured employer, rather than a producer who may not have insurance and may not be solvent, and he may not be nowhere near you, whereas this guy's on your doorstep. So a whole lot of reasons why that's the clever thing to do.
Yeah, it's just so different.
It is. It's.
Think about this in the US, I want to sue everybody I can who actually is liable. Because in the end, what I'm going to end up doing is settling. And so there's not going to be a constraint on the amount of damages I can recover, other than how many people I can find who potentially are liable. And that's the mindset.
I think another culturally is. When you think of it, we're now 2012, and there've been only four asbestos cases in the highest court in the UK, probably maybe 10 in the Court of Appeal, and that's because this whole machine operates on not class actions but on lead cases. So Fairchild was simply a case with three guys, Sienkiewicz, 2 people, Barker and Corris, I think there were 2 people, but they're representative, and once they set that, then basically people settle, or the trial. It's a very, very narrow pyramid. Very few things get up, but once they're up, they determine the rules and because reasons are given at every stage. The judiciary is elite. They're very careful, so the reasons tend to think through all the different permutations, so that there's a lot more guidance, I think, for settlement.
And there's lots of protocols in place to try to encourage settlement, particularly post-rule reforms, et cetera, and
Yep.
solicitors are Sorry, there's a lot of protocols in place to encourage settlement on all sorts of different subject-specific areas. The culture of the solicitors and the barristers is not to encourage litigation, but to encourage settlement in appropriate cases. And if you have no jury situation where you have, as you've mentioned before, Jane, you know what an arm is worth, you know what a leg is worth, et cetera. It's all set out in the Personal Injury Law Quarterly, et cetera. You know what that tariff is. There is no incentive to litigate, particularly when you've got loser pays rules, et cetera. There's just no incentive to do so. And it's a much smaller jurisdiction. You don't have the conflicting jurisdictional, there's no circuit splits. You have one court of appeal. So.
I guess you pursue only your best claims mainly because there is a fee shifting rule.
Well, it's funny you say that, because Actually, an exception that maybe proves that rule is a case called Gregg and Scott. Gregg and Scott was a case where a claim was taken by a person who, on the basis that his doctor had failed to diagnose cancer, whatever. What was extraordinary about this case was that he hadn't died yet. And so it was almost the weakest loss of a chance case you could take. So it wasn't you select your strongest case and you take your most poignant case and you take it up in order for them to create a new doctrine in your favour. It was actually, again, I'm aghast it actually got to the House of Lords because it seemed to be obvious they were going to throw this out because the person's chance that they'd lost was changing from day to day according to what his prognosis was. It was just crazy. And I do know of a landmark case where that was exactly so. The defendants were pushing it so that they could get a weak case thrown out.
Professor Sanders, you had a question?
Jane, I just wanted you maybe to elaborate on why you think, in fact, the Fairchild Doctrine will be expanded to all of these cases.
Yeah.
So I'd just like to hear a few of your thoughts of why that's so.
Well, I start out by saying that those who read Sienkiewicz, if you want a bit of entertainment, read the very short judgment of Lord Brown, because he goes ballistic about the whole doctrine. He's basically, it's a huge mistake. Let's never do this again. Let's never have a special causation rule. Foaming at the mouth. And so you think, okay, so there's a little unease about the whole creation of it. Personally, I think I was sitting in Fairchild. I wasn't actually involved in the case, but I went and sat in this 3-day hearing, and it was remarkable. Because remember, the assumption they made was that all the sources of risk were due to torts. And you had the hunting cases, and you're thinking, they can't. But at one stage, defence counsel is arguing to the House of Lords that they can't prove it's my person. And the other guy, I can't prove it's my person. And Lord Bingham, who lovely man, but in court was like an Easter Island statue, sort of Easter Island statue. But anyway, the eyes come up, and he says, "So, Mr. So-and-so, are you saying it's the law of England that if I'm living in my home and on the one side I have an asbestos factory polluting me in breach of duty for years, and on the other side another one polluting me, are you saying that, and I then contract mesothelioma from asbestos, are you saying to me that the law of England provides me with no remedy?" And of course, the defence counsel said, "Well, yes, my lord, that is my submission." And so the eyebrows of the Easter Island statue just rose, and you knew that they were going to do the right thing. And on the assumption they'd made, how could you not apply the hunting cases? So I think Fairchild was a great doctrine, but now because they've extended it into these other areas, and the killer thing was Section 3 of the Compensation Act. Now, that came in after Barker. Now, I was involved in Barker, and the interesting thing about Barker is it was actually run by the government. The people funding us, the defendants in Barker, were the government, because they could see this huge phenomenon. They're the deep pocket, never go out of business defendant. And they thought, oh God, we're on the hook with Fairchild. Let's at least get, aliquot liability. So they ran Barker and Corris to get aliquot liability. We got it. Same government, their backbenchers went and said, we're going to put Section 3 in there, and if you don't put Section 3 in this Compensation Act, only a month or so later, we're going to have, a vote of no confidence in you, Blair, your government. So you had the government, on the one hand, achieving a legal rule they wanted, and the backbenchers smashing it. So with Section 3, you see, you now have this perfect storm for the government. And what I think is going to happen is that even if, when this case comes up, and say the Supreme Court says, like Lord Brown, we're not going to expand this doctrine anymore, it's a mistake to begin with. If they do that, you'll get the backbenchers just coming in and sort of saying, no, we want these people to win, even if the innocent fibres, they'll just do an equivalent. At least that's my suspicion, that they're not going to let the court take away the entitlements of the workers. I might be wrong on that. That's just a political guess.
More questions? Well, I have a question. I am thinking that, I mean, you seem to think that this the kind of criticism of the UK courts towards statistics, towards, I mean, the attitude to scientific evidence and statistical experts. And I am wondering if it does, I mean, if you can explain there is something cultural there, because you mean at the beginning you seem to compare with the US. You said, well, in the UK we are suing employers, and in the US they have working compensations, so it works different. And also you are talking about the attitude about this scientific evidence and statistics. You think there is some cultural thing there?
Okay, let me take the last bit. In the longer paper, I make a point that I didn't make in the talk, which is that there's a dynamic that goes on in the States which completely distorts their tort system, which is the sole remedy rule. And that is, in our system, if someone says, you, my employee, you must go work on this machine with a blade without a fence on it, with bad lighting or whatever on the machine, and your hand gets chopped off, in our system, the person you sue is your employer. In the States, 90% of employees can't do that. So they have to go find the person who made the machine without the guard. So you get this odd system. And for any one injury under the special products rule, you not just get one supplier, but a sort of cascade of potential people. So in asbestos, you get cascades of people are responsible for any one exposure. So you get a huge array of people you might sue, and because you don't have compulsory insurance behind these people, you need to sue them all. So they've got a whole different problem. But the thing about, I'm not sure, you've got the world experts here on toxic torts in America. I don't know what the expertise is like, but I'm always surprised by the lack of scientific understanding in the UK, because there's an elite bar, an elite judiciary, very few cases get up. It shouldn't be rocket science for these people to get it right. They had this enormous disaster with Sally Clark. They had the Royal Statistical Society bashing Lord Chancellor in public about not allowing non-statisticians to give statistical evidence, and yet here you have the most important asbestos case going up right to the top with such a fundamental flaw in it. So I'd like to be able to explain why in both systems we can't seem to integrate basic statistical understandings with law, but we seem not to. I talked to the professor of statistics at both Oxford and Cambridge, and one at Oxford sort of summed it up for me. He said that the problem is, in most other areas, people understand they don't have expertise. So you wouldn't, but with the guy Meadows who testified in Sally Clark, he was a doctor, and he used numbers all the time. He felt confident that he knew what numbers meant. So he multiplied these two numbers together. He was comfortable with numbers. The QCs were comfortable with him because he was a knight. So everyone's comfortable. But as my statistician said, well, a truck driver goes across bridges all the time. He's very familiar with bridges, but you wouldn't ask him whether the bridge was structurally sound. So familiarity breeds a sort of arrogance with some of these concepts. And I think that's part of that's going on, that lawyers who deal with a lot of medical malpractice cases get overconfident, and I think people rely on their first form mathematics and feel confident they understand statistics when they don't.
Thank you. Any other question? No? Well, okay, we're going to break, a coffee break, and then we are going to be back for the second and last panel. Thanks so much. Thanks, Professor.